Case number 14, People v. Cheng Lin. Ms. Powell, good afternoon.
Good afternoon, Your Honors. My name is Denise Powell. I'm here appearing for Cheng Lin. Detention and interrogation.
Would you like rebuttal time before?
I'll reserve 1 minute, please, Your Honor.
One?
Yes, please. Detention and interrogation are tools, useful tools in law enforcement. But there is a line dividing permissible police conduct and that which offends due process. The line is drawn where conduct undermines a defendant's ability to make a reasoned and free choice as to whether or not to speak or not to speak. When the conduct creates a situation where the defendant becomes an unwilling collaborator in his own demise in establishing his own guilt, then that conduct violates due process. The facts in this case show quite clearly that the police crossed that line. In this case, it's undisputed that Cheng Lin's confession to first-degree murder was obtained only after he was subject to repeated rounds of interrogation by teams of
well, this is different from some cases where the interrogation went on for many hours with investigators coming in repeatedly, keeping the defendant awake. It seems to be a little bit different here, where the first day he was there voluntarily, he went home, he had an opportunity to have a good night's sleep, and then when he came back, the record seems to indicate that he was interrogated on and off. He was given breaks. He was given food. He was given cigarettes. You know, it's not the typical, other than the length of time here, it's not the typical coercive, you know, keep at him kind of facts that we sometimes see. So, you know, what is it exactly here that you claim proves so definitively that this was involuntary?
It's true. This case is not a case where the questioning was continuous. Whether or not the questioning was continuous bears on whether or not it deprived the defendant of sleep. In this case, we have 4 days of interrogation. He's put in a 12-by-12 room without a cot, without a bed to take advantage of the breaks between the interrogation. And given that lack of the means to take advantage of the opportunity to sleep, he was deprived.
We don't have any fact-finding authority here, of course, and so the appellate division made a decision. Did they violate a standard of law in your view that makes this reversible on that ground?
What the lower courts found, interesting enough, is that not that Mr. Cheng Lin, in fact, slept, but that he was simply given the opportunity to sleep. And my argument here is that just giving the defendant an opportunity to sleep in the circumstances in which he found himself in a 12-by-12 windowless room without a cot, without at least a bench to sleep on, he was deprived of his right, of his ability to take advantage of the breaks and to, in fact, sleep. But what's here, I think, what makes this case truly remarkable is the fact that, yes, he was interrogated over a span of 4 days. First day he was allowed to go home, true, but only after they extracted from him an agreement that he is to return. And he did. And the very next day, he was returned to the precinct. He was put back into the same exact room, the 12-by-12 windowless room.
Well, nothing prevented him or anyone in his family from calling a lawyer, correct?
I'm sorry, Your Honor?
Nothing prevented him or anyone in his family during that period of time in contacting a lawyer, correct?
There's nothing in the record that shows that he had access to it.
And he said, yes, as long as you pick me up, didn't he? Right?
He said he agreed to come back.
Some almost a bargaining arrangement going on with these police, did he not?
That's correct. But that's the first day. He then comes back.
It's really not 4 days. You started out with 4 days. You're really talking about 3 days, no? Because he went home that first day.
No, yeah, I'm not saying that he was in custody for 4 days, and I want to make that perfectly clear. He was interrogated over the span of 4 days and intermittently agreed I have no qualm or no question about that.
Counsel, was there anything, since the police allowed him to go home the first day, was there anything preventing Mr. Lynn from saying, gee, I'd like to go home and get some sleep and come back again tomorrow? Did anything prevent him from asking them that, since they'd already shown that they were willing to let him go home and come back?
I'm sorry, was there anything preventing him from asking to go home the
Yeah,
following?
or saying, I'd like to go home and come back.
Well, he was put in a room.
Well, he's put in a room the first day, too.
And it was the same room.
And in his mind, as we know from the doodles or his notes, he felt as if he could not.
Well, that was on the first day.
That was on the
you
first
can't-
day.
Yeah, that's not offered for, well, and if that's true, he went home, so it was disproved.
You know, the thing that struck me the most is not the period that he was in interrogation. As you can tell from our questions, this doesn't compare to many of the more onerous interrogations that we've seen before. What struck me, though, was the lengthy post-arrest arraignment delay, which is the 28 hours from when he was charged with robbery to when he confessed and then he was arraigned. That seemed to me to be to really, in focusing in, that seemed to be the core of your argument. I'd like you to address that.
Correct, Your Honor, but I don't want, I didn't want the court
No,
to
I
lose
understand.
sight of
And you're
all
trying to
the
go in order
other
of your
things that
brief and
occurred.
everything else. I understand all those problems. But the heart of it here is that, because the coercive interrogation, I don't see that here. But the question that's much more difficult for me is the post-arrest arraignment delay.
Well, I think that the post-arrest delay in arraignment feeds into and supports the coerciveness of his statements.
Well,
And
what I
that is
see it
what
feeding
makes-
into is that the police saying the longer we can keep him from doing that, once he gets a lawyer, we won't be able to get a confession out of him. So that's what the
Correct.
point of a post-arrest arraignment delay argument is.
That's
So,
correct.
The federal rule is 6 hours. In New York, usually it's about 24. Here, it's at 28. So why isn't this just one factor rather than an overriding factor?
It's an overriding factor because of the particular facts in this case. So prior to, let me just go through it. The first day, he goes home. Second day, he's interrogated again. They start at 11:40 in the morning. They go at him, not continuously, intermittently, and by 9 o'clock, he throws in the towel and then makes a statement. Not confessing to first-degree murder, but confessing some level of culpability in connection with
Some
the murder.
knowledge of what went on.
Not just knowledge, Your Honor, it's
I'm trying to help you out. What I'm trying to get to is, I think, what Judge Fahey is raising. I'm not persuaded by the 4 days long, we're familiar with these rooms. We threw out 36 hours in certain circumstances with no food, et cetera. But it strikes me that you're supposed to get arraigned speedily. And court congestion can delay that. Understand. But if the police are getting into a situation where they say, you know what we got to do here is we've got to hold up the arraignment, or as Judge Fahey was suggesting, maybe we don't want him to get a lawyer right now. If we've got him halfway to a confession, let's keep him here, even though we can get him arraigned this afternoon, so that we can get a confession. That seems to be a very strong point. So I don't want you to waste too much time on those other days. I think we understand what you're trying to get
Right,
to.
so I just wanted to make sure that it's...
Believe me, we
no,
do.
okay.
Yeah.
All right, so, yes, so he makes an inculpatory statement at the end of the first day. Not only does he make the inculpatory statement, but they arrest him, and they inform him of the arrest, and then they keep him there for 2 more days. That, I think, is what makes this case
How many
truly-
hours or how long after they know about the blog do they keep him?
How many hours?
Once they know about Simon's blog, which
They-
seems to be the point in time when I don't see how the people can argue this person isn't a suspect in this murder. At that point, yes, they're thinking this is the guy who killed him. So how many more hours do they keep him after that?
Well, the answer to your question is they learn about the blog at 7 o'clock in the evening on the third day that he's in the
After he's been arrested?
After he's been arrested, and I just want to make sure, he is a suspect at that point in the murders, because he already said, I assisted Gong and the Fukinese man.
Okay.
But so they
How many
learn
hours
about-
after the blog?
So after the blog is learned at 7, They then go in at 9. They then confront him at that point about the truth of his earlier statements. So, and then he starts sobbing for 15 to 20 minutes, and instead of giving what is constitutionally his due at that point,
Well, the question was
continue-
how many hours? I think Judge Rivera, we're trying to get to, we can't say, well, he started crying here, and therefore we're going to reverse this case. What we can look at are, our standards and rules, and one of them is that you got to take someone to be arraigned speedily. And so I don't mean to put words in Judge Rivera's mouth, but she's saying how long after the blog, when they had relatively conclusive evidence that he committed the murder, did it take them to get him in front of a judge?
He's, okay, so the blog is discovered at 7. He's not arraigned, I believe, until sometime, it can be, since I only have the online booking sheet, he's taken down to central booking the following day at 18 minus 12, 6, I think 6:37. So the earliest he could have been arraigned is the following day, at sometime thereafter. But the point is that the arraignment delay time runs from the date and the time of the arrest, which occurred the day before. So we're talking about not just, we're talking about a full 2 days,
the
37
people
hours.
say he's the one who's got the information, and the delay is really due to the fact that he keeps giving these different versions of this story. And this last story, when they're arresting him, is that there's Gong, and then there's Fukinese man, and they're trying to get information out of him so that they can track down those people. And they say that's what's delaying this, trying to do our investigation with a suspect who continues to change the story and uproot and upend the process that we have in place to really surface these facts. Let me ask you this. That's not necessarily without some compelling aspect to it. At what point can police do what they were trying to do here? Is they have information, they're going to arrest, but they know that this is the person who has information to get them to these other suspects. Can they ever hold someone like that? Can they ever delay the arraignment at all? If so, for how long?
Once the statute is clear, you make an arrest, you gotta take the necessary steps to move him from the precinct for arraignment. That's the statute. So at that point, when they arrested him at 9 o'clock on the second day that he was in custody or in the precinct, that's when the time runs. Not when the blog was discovered.
It's regardless of what other information he may have of any other potential suspect.
If they want his help, I have no problem with the police obtaining his help, but they've got to do it within the Constitution.
Well, you know what they'd say, though? They'd say there isn't a bright line rule in New York. So from the other side, what they would say is that the defendant created the situation because he attempted to mislead the police and he caused a delay. So the delay is on the defendant.
He doesn't lose his constitutional rights. He has every right, and he has a right under the statute.
I accept he doesn't. We all accept that. But the question is whether 24 hours, we wouldn't be having this discussion. 28 hours, we're having this discussion because then it's moving beyond what this court has held to be reasonable before. So why? Why shouldn't we accept that argument?
Because the rule is simple. The statute says if you're going to make a warrantless arrest, the only elements that make it reasonably necessary to delay an arraignment are things that relate to processing a defendant for arraignment. And the people essentially
Does your approach
concede.
incentivize the people or the police to delay the arrest? To keep talking to him, to get more information? They're not sure what to arrest him on. Maybe he knows more because he keeps changing this story.
It might raise that. However, it seems to me that once there's probable cause, then there's another argument that can be made.
Thank you, Ms. Powell. You have your rebuttal time. Ms. Spinakos, am I pronouncing your name correctly?
Yes, you are, Judge.
Thank you.
Good afternoon. May it please the Court. Anastasia Spinakos on behalf of Richard A. Brown, the Queens County District Attorney.
How would a defendant ever establish that the purpose of delaying the arraignment was to try to extract a confession without an attorney? What would they have to show? How would they do that?
Well, they have to show facts that are not present here. They have to show facts like you have in some of the other cases that have been before this court, like the Guilford case or the Thomas case, when the police are constantly questioning a suspect in the effort and in the attempt to get him to inculpate himself more. That's exactly what we did not have here. Okay? The officer's intention was demonstrated.
We said there it wasn't, we said it wasn't voluntary for all of those reasons, but I thought that went more to the coerciveness than to the delay. I'm sort of asking you more directly about the delay between arraignment and between arrest and arraignment.
Correct. That delay would have to be designed to get a more inculpatory statement.
Well, I'm not sure we said that. I think what we said is you got to move them toward arraignment, and court congestion, things like that, things beyond the control of the police are excluded. But I guess the question here is if they were holding him for purposes of further investigation, attempting to get other statements, whatever it was, can they do that on their own after an arrest, or do they have to take him to be arraigned immediately?
Well, it depends. In this case, it depends on what arrest you're talking about.
Well, let me make it clearer for you. Is it the police who make that determination that we are not going to arraign this? We can take this man across the street, not your case, and arraign him, but we're not going to do that because we have questions for him. And so we're going to ask him a lot of questions between now and 4 o'clock when we'll take him over, and then he'll get arraigned and he'll be told he has an attorney, and we're going to be out of luck. So we are making the decision to hold him for purposes of further questioning, even though we could arraign him now. Can they do that?
Well, since they're the ones in control of the situation, I mean, obviously they can do that.
Well,
okay?
I think you're – wait. Sure, they can do it. They can hold him for 3 months without telling anybody. I'm not asking you that.
Okay.
I'm saying, is it proper? Is it legal? Is it what we ought to be endorsing, that the police make the determination between arrest and arraignment as to how long that's going to be, or is it the courts? I assume it's the courts since we've already said it. But having said, within 24 hours, generally, can the police say, okay, we've got 24 hours, we can do anything we want, and if we want to extend it, we can do that too?
Well, they'd have to have a reasonable basis for extending it. They can't just keep him there indefinitely to run out the clock.
Here's the argument that's being made. It's further investigation. I hate to have a hard and fast rule, but recently the Massachusetts court has adopted the federal rule of six hours. You've got to be arraigned within 6 hours. But it's hard for me to envision an arraignment that couldn't be delayed by a need for further investigation. It seems that the police could justify any delay in arraignment by simply citing the need for further investigation.
But they'd have to support that with record evidence, Your Honor. They'd have to support that they actually are investigating the matter further, that there is something else to investigate. It can't be the defendant confesses.
Well, wait, there can always be further investigation. I would think no matter what the charge is, you can always say, we had phone calls to make, we had research to do, we had I guess I'm trying to get out to the point where the police have got to say, we can't do this. Sure, we want to investigate. Sure, we want to do this stuff. We can't. We've got to get him over and get him arraigned. Otherwise, they're going to dismiss the case on us.
And in most
Looking for that point.
In most of the cases in New York City, that's exactly what they do. They're arrested for a particular charge. They have a victim saying, this happened or that happened, and they have probable cause, and they arrest the individual, and then they process them. Then they can go about. Here it was very different because the defendant was claiming that this brutal homicide, double homicide, was committed by 2 other people. He was not involved directly in that.
Then they had no grounds to arrest him, is what you're saying.
I didn't say they had no grounds to arrest him. He inculpated himself in arranging a robbery that led to the death of these 2 people.
Then they had grounds to arrest him and have him arraigned. We want to say, I'm making this up, we want to say, look, let's make this clear for you people. Once you arrest somebody, you got 7 hours to arraign them. Very clear, know what they're doing. In this case, they probably wouldn't have arrested him right away. They would have continued their investigation, but there'd be a clear rule. The trouble, the worrisome thing here is that the allegation is the police are trying to deprive a defendant of his right to an attorney and whatever other rights spawn from that. Now, I know that's not true, but how do we establish that? How do we
Well, we know that's not true in this case based on the facts and what occurred here. And to establish such a bright line rule at 7 hours, I would suggest to all of you that that would really be quite onerous on the downstate counties.
28 hours, it was 48 hours, or it was a week, because he's essentially, if this defendant is lying about Gong and the Fukinese man, there are no such people. So the police could be running all over town, asking people in the community, there's all kinds of investigation they could do, and it might take them days.
And
Does that make it appropriate for them to fail to arraign the defendant while they're doing that legitimate investigation?
You have to keep in mind that what the officers were aware of at the
Is that a
time.
yes?
That's a qualified yes.
So they can keep him for a week?
They could keep him for some time, okay? And there's no set fast rule how long they can keep him, but
We're trying to give you one. Do you have a time that you think would make some sense? I mean, we've said in our previous cases, 24 hours seems to be about right.
I think 24 hours is appropriate. And in most cases, okay, at least out of Queens County, they are arraigned within the 24 hours.
This one didn't make it.
This one did not
And
make it.
And Ms. Powell wants us to throw the case out because you didn't arraign him within 24 hours, and you have no good reason for not doing that.
I would disagree with that completely. We had a very good reason. The officers were investigating this double homicide. They were told by the defendant that 2 other people actually committed it. It was not him. And these people were then going to go and use the proceeds from this and go and commit another, violent act in another state. The officers were not looking, when they kept going back in to speak to the defendant, they weren't looking to get him to inculpate himself more.
Well,
They
but
kept
that's sort of his word against his word. I guess the question that I'm trying to get at is that what the statute intends, is to allow someone to be held while the police do further investigation, whatever that may be? Or it seems to me that that's not what the statute says. The statute is a much more practical statement of, you need to get the wheels in motion to get this person in court, and I don't think there's any evidence in this record that that was happening, because the police felt that they were entitled to hold off while they investigate. And that's the question. Are they ever entitled to hold off for the purpose of further investigating the crime?
The statute is written to get most people through the arraignment process as quickly as possible. But there are those cases that just don't fit within that 24-hour rule. And there's a case cited by my adversary in her reply brief, the Brown case, which talks about that. It was a habeas corpus where, people were coming in and complaining about how long they were being held. Okay? And in those cases, in the trial court, in those cases, the court said that in normal circumstances, the 24 hours should be applied. This is not a normal case. And the normal rule.
I think we all know that. I think what we're trying to get at, let's assume it's not normal. How long do you get? Do you say it's not normal 3 months? Do you say it's not normal 1 month? Do you say it's not normal a week? Or do you say it's totally within the discretion of law enforcement? We decide when arraignments get made.
There's no hard and fast rule.
The answer is that the police decide.
No, obviously the courts make that decision. But when you have unusual circumstances.
Okay, so
that
what makes
don't-
it so, let me go back to that, because you say it's not a normal case, it's unusual. What makes it so unusual and not a normal case? You've got a defendant who's giving you all different kinds of stories.
But the
They get enough information that they are now, and based on his statements, they arrest him for his involvement in the robbery pursuant to,
Correct.
and then results in this murder. Okay, so what makes it so unusual? The guy lied. He lied several times.
Right, but what
Is it that there are exigent circumstances?
that definitely
And
exists
you
here.
argue that below, that there were exigent circumstances. This is not like the Boston bombing, right? This is not like you have a terrorist and people might die if I don't get more information out of you right now.
It is not a terrorist situation, but we did have a situation where he implicated these other individuals. We're going to use the proceeds from this robbery to do another massive, I think, home
You
invasion.
don't have the time frame for that. It's been days. How much longer are you going to hold him on that? Again, we're getting back to Judge Pigott and several questions around that. But this sounds to me like it's not that unusual in the sense of you have a defendant who's giving you all kinds of stories. And of course, what we have not said and what you have not said is You could continue to investigate while he's being arraigned. You had a certain amount of information. The police could have continued. What the police did not want is they just didn't want him to have his attorney next to him
No, Your Honor.
while they asked questions.
That's not true. They could not continue this investigation without defendant. Defendant was the only person who could identify Gong and the Fukinese man.
Okay,
So,
before you, I apologize, but do you want to be heard on the other issues, the videotape?
just briefly, Your Honor.
What struck me was it was your evidence, and for some reason the defendant couldn't use it. I didn't understand that at all, and I particularly didn't understand it once the judge said you can use a picture from it. I mean, if you can use a picture from it, why can't you use it?
Because the video itself, as my adversary points out in her brief, and she uses it, it's strikingly what is about the video was that, you know, it put in front of the jury, whether he wanted to argue it or not, his ability or inability to speak English. Since he was disavowing that numerous times from the trial court didn't want to put in the 6-minute video. The trial court's ruling in that respect was proper. Defendant never...
Wasn't there a lot of rebuttal evidence, even if the video had come in? Wasn't there a lot of other evidence that this man spoke English, that, you know, he understood his rights, he had already agreed to some Miranda warnings before? Why keep the video out? Because it would show that.
Because then we're just putting this little mini trial in front of the jury regarding his inability or ability to speak English.
But you did it. And it's not his ability. They wanted to put it in to show how haggard he was because of all of this questioning. And it was your. I just don't understand why you thought it was smart to videotape this guy. So you videotaped the guy. He didn't do apparently what you thought he was going to do. Not you personally, of course. And so now you want to keep it out. And
We asked to keep it out because we didn't think it was relevant for the purpose that counsel was asking to put it in for. It wasn't relevant to show anything about his demeanor that showed that the earlier statements were involuntary. There was nothing about the video, and still on into this court, defendant doesn't point to anything in the video that demonstrates that his earlier statements were voluntary.
no, he looked haggard. And I thought, I mean, that's the argument that that he was haggard, that he was beleaguered or something. But you can instruct on that. I mean, you can bring that ADA in, who's sitting there, and she could say he was fine. He was just acting for the camera or whatever.
Right, we could have done all that, but that would have brought like this little mini trial at the trial regarding the
But he's on
issue.
trial for murder.
Yes.
I mean, that's kind of important.
What was the prejudice to you, to the people?
The prejudice of people?
Yeah, I mean, if all it showed was that he was haggard, or even if he tried to show in the face of all this rebuttal testimony that he didn't speak English very well, what's the prejudice?
We didn't want to have to go through putting all that before the jury. We didn't want to obscure the real issue. When counsel was saying, I am not going to make that argument, depending on the evidence, I'm not going to make that argument, and kept waffling on that, we wanted to make a very clear presentment to the jury of what the evidence had.
Of course you did, but they want to do the opposite. And, I get your point. It just seemed to me that at some point you start thinking, they're not letting this guy breathe. I mean, the defense counsel is trying to put in, it's pretty innocuous evidence, and the DA's pounding it, saying, you can't come in because it's a mini trial.
But it wasn't relevant for the purpose counsel asked. But even if it should have come in this case, there was no reversible error here because the evidence of defendant's guilt was so overwhelming. All that video was for was to show that his statements were involuntary. Even without all the statements in, as the prosecutor argued on summation, there was more than enough evidence to establish defendant.
The prints on the wall, the prints on the duct tape, adhesive,
The duct
his
tape,
own admission that he's there.
It's in the duct tape, on the duct tape roll, demonstrating he was holding the duct tape with one hand and pulling it, okay, on Simon, the brother, his fingerprint on Simon's wall, and while counsel says it can't be harmless because, he dated the sister and he could have his prints there. Well, actually no, because they had moved into that apartment quite a while after she had broken up the relationship, and Simon was kind of a private person. There would be no reason for him to be in Simon's room. Then on top of that, and the reason why the people put in the photograph of defendant was to show the scratch on his forehead, and his DNA was found under Sharon's fingernail, the other victim.
If the confession is allowed in, that's pretty. The evidence may be overwhelming, but it also has to be no reasonable possibility that the error have resulted in a different result, right? There are two stages to our analysis here as to whether
Correct.
it's harmless. So if the confession is allowed in, and he's challenged, and he's attempting to persuade the jury that it was involuntary, then doesn't the lack of his ability to use the videotape and other evidence just hamper his ability to question that confession, that admission, which isn't just a minor thing? Could have changed the result, maybe.
I absolutely would not have changed the result. Take out the confession, the statement completely, had we not been allowed to use that. There was overwhelming evidence of his guilt. There was no doubt that he committed these heinous crimes on his own, personally, individually. He was the one. He was there. We have the blog. We have the DNA evidence. We have his fingerprint evidence.
I know you've gone way over. It's just one question. It's not what is the process now when you have someone, let's assume that for the moment, the defendant is correct that he really has a limited understanding. It's an accurate representation of his understanding of the English language, which he didn't understand what it meant to say you have a right to an attorney, you have a right to speak to an attorney before you speak to us. What's the process now? Because I found this striking that there were cops who came in and spoke to him in his native tongue,
Right.
but you'd keep having cops come in and speak in English. So obviously someone realized it might be more effective to get to this guy in his own language. So I'm just curious, what is the protocol today?
Well, when the officers need somebody to speak that language, they have more than enough staff that they will have.
Yes, and how do they know they have such a need?
Well, if they can't communicate with the person. Which
What if
didn't-
someone has a limited ability to communicate, gets across something in English, but is not really fluent? I mean, certainly this person, at least from what you've got in the record, it appears on its face he's got some limitations. He's not fluent in English.
But he also went to school here for years, and the officers
Yes,
had-
there are people who've been in this country for many years and gone to school here and don't speak English very fluently. So, but that's not my question. My question is, how did the police deal with someone who doesn't have a good understanding of the language, is not able to communicate, may have some real limitations, and there may be doubts as to what they understand?
What the officers generally do is get a fellow officer who speaks that language and have that officer
So they had
assist
that
them.
officer here. Why didn't they just keep Huey or I can't remember who was the attorney. I think it was Huey who spoke with him, and Wong perhaps.
Yes.
Why didn't they stay on this case? Why did they have other people
Because
really
defendant,
talk to him in English most of the time?
because defendant exhibited an ability to speak and converse with the officers, and nobody had any problems understanding him, and he didn't indicate any problems understanding them. When the other officers went to speak to him, they had no problem with him, understanding. He didn't indicate any inability to understand what was being said.
Now we're here, so say you, and he says otherwise, but, okay.
Thank you, Ms. Banakis.
Thank you very much, Your Honors.
Ms. Powell, you have a minute.
Just very quickly, the tape amply shows that this man, while he may very well have been able to communicate some ideas, some thoughts between himself and the officers, what's critical here is, did he understand the word attorney, and did he understand the words right to remain silent? And
But defense counsel kept saying when he wanted to offer the tape, I'm not offering it to show that he doesn't speak English. I just want to show how.
That's true. Actually, Your Honor, I was referring now to, because I didn't reach the Fifth Amendment claim. There are separate claims here. There's a due process problem, but there's also a Fifth Amendment problem. Our argument in subpoint B of 1 is that he was never effectively given his Miranda rights because he didn't understand them. And this Court has held that when you give Miranda rights to a person, it at least has to be in a language that the person understands. And the tape amply shows that this man did not understand those words.
Yeah, he understood some things, because when it came to whether he wanted to speak to the ADA who was videotaping him, when he realized that he could have a lawyer, he said, no, I don't want to talk to you, and that was the end of the interview.
But, Your Honor, that was after when she said you have the right to an attorney, it basically said, I don't know what that word means.
Yeah,
and she
yeah.
said that means a lawyer. Then he understood,
Yeah.
right? And also the right to remain silent. You have to understand at least those two. That's just fundamental to understanding one's Miranda rights. With
Thank you, Ms. Powell. I think we have your argument.